Hello, everyone, and welcome to the Employment Law Counselor Podcast presented by White & Williams, LLP. I'm your host, Jeff Stewart, and each and every episode, we tackle the laws and regulations that make up the world of labor and employment law. Today, we'll be covering what you do when you get an EEOC charge. While our podcast is not legal advice, it is a practical discussion between two attorneys that deal with the maze and minefield of labor and employment laws on a daily basis. If you like what you hear, please give us a 5-star review and subscribe so you never miss an episode. As always, I'm joined by one of my colleagues at White & Williams to discuss our topic of the day. Today, I'll be joined by Nancy Conrad, who works with me in our firm's Lehigh Valley office. How are you doing today, Nancy?
Very well, thank you. And you?
I'm doing well, and welcome to the world of podcasting. I believe this is your first ever podcast episode. Am I correct?
That it is.
All right. Well, welcome, and hopefully I don't scare you away. Why don't we dive right into our topic? So, Nancy, let me ask you, when you get an EEOC charge for a client, and let's say it's a client you haven't dealt with previously, what do you do? What do you need, and what are you trying to learn immediately about both the client and the charge?
Well, Jeff, the first thing I want to do is review the actual charge of discrimination. And the reason is contained in that charge will be not only the claims that are asserted, but there will also be, oftentimes brief, although I have had charges with over 100 paragraphs, a description of the factual allegations that form the basis of the charge. After I've done an overview of the EEOC charge, I then want to meet with and understand the client. I want to learn about the client's industry, the operations. I want to better understand the employee relations that the company has with its employees. And I want to know upfront whether or not there is insurance that may be applicable to this claim, because notice must be timely. And I want to be very certain that the client has all the protections that are available to it.
And I think that's an excellent point, because most insurance policies require that if you give notice and prompt notice, and if you don't do that, the client may unfortunately lose the insurance coverage that, frankly, they've already paid for.
Exactly. And Jeff, before we move on, there's one other important understanding that I want to gain up front, and that is an understanding of what the client's ultimate goal is in this matter. There are some companies that want to resolve these matters quickly and efficiently. There are other companies, especially when the claim goes to the heart of the operations or involves a matter of integrity or principles, that company wants to litigate sometimes and establish that it did not engage in any wrongdoing. So as we plan a path forward, it's important to know what is the ultimate goal, although that goal may change as we proceed.
And one of the things that I try to get a grasp on real early in the process is who was the decision maker when it came to that employee, and it's not always the same person, who's the decision maker going forward in how we're going to handle this response to this charge. Because maybe a frontline supervisor who dealt with this employee in the past, but it might be the vice president of HR, it might be the controller, it might be the president of the company who's dealing with the response to the EEOC charge.
And Jeff, that's so important to identify early on, because while the attorney-client privilege attaches to all of our communications, provided we are providing legal advice and the material is deemed confidential, in terms of strategy, I want that privileged conversation to be with the decision maker with respect to the overall litigation. And that may be a different conversation than the conversation and the meeting we have with the supervisor who made the decision with respect to this particular employee who filed the charge.
Absolutely. Then I want to go back to something you said earlier. One of the first things you want to do is really get a feel for the client and what it is they do. Personally, I find it effective to go to the client's location, to meet with people. If it's somebody who works on, let's say, an assembly line, to actually view the assembly line and get a feel for what it is that they do. I'm assuming, Nancy, that you do the same thing. I think that is invaluable from my end.
Absolutely. I recall a case which actually went to a full jury trial, which involved the termination of an employee who failed to place a tag on his gas line. It was a welding job duty that he had undertaken. And while admittedly, I have been many times to many different places of operation, I needed to understand this welding process. And I actually was on site with the gas tag in hand and tracked how that tag gets placed, the gas line gets hooked up, and the implications if that very particular safety procedure is not followed. And I could only understand it and then describe it to an investigator, to a judge or jury, because I had been there, I had seen it, and I had experienced it.
Absolutely. I think there is no substitute for actually being there and getting a firsthand account for what the employee does. Now, I want to go back to the charge itself because as you know, and I'm assuming many of our listeners have had some experience with an EEOC charge. Many times it's a single piece of paper and there are certain parts that are check the box. It's discrimination based on race or disability or, there's a retaliation claim. But I think it's important to note that you can't rely just on the boxes because if the written narrative, let's say, contains age-based comments, the EEOC is going to read that as also having an age discrimination claim, even if age, that box wasn't checked.
We can't emphasize enough the importance of that piece of paper or that electronic transfer of information. And you are 100% correct. Not only do you have to look at the boxes that are checked, as you noted, whether it's discrimination, retaliation, or what type of discrimination, race, national origin, age. The text is also important. And we've all experienced that 9 times out of 10, the descriptions are inflammatory, exaggerated, but oftentimes there are elements of truth contained within them. And that's where it becomes important to delve into those factual allegations, to separate out that which is accurate from that which has been embellished, exaggerated, and in many cases, made up. Another important distinction with that narrative, in addition to what you noted as to the potential of a harassment claim, in addition to the discrimination claim, the references to individual employees, especially supervisors, often are a signal of a potential claim against an individual, which under our state statutes, an individual can be held liable. That creates a whole nother chain of events in terms of dealing with a potential individual respondent who may become an individual defendant.
Absolutely. One of the first things I do when I look at that charge is I circle any name that's on there and I want to talk to those people immediately. I want to, number one, let them know that they have been named in some way here, but I want to really make sure that I understand their role in everything that happened. Is there potential liability? Is this person just a witness, or is that a comparator for a discrimination claim where somebody is alleging that they were not treated as well as someone who is named in the charge itself? These are all things that we will need to look into.
And a cautionary note is that if the individual that is named is an alleged harasser, alleged to have engaged in sexual harassment or have made racial discriminatory comments, that in and of itself is notice that there may be a potential conflict here, that that employee may have acted outside of the permissible work rules. And as such, that creates a conflict where I, as attorney for the company, may not be able to represent the individual employee. And we need to have a frank conversation at the start as to whether separate counsel is needed. And if so, how we go about that process, because I do not want to meet with that alleged harasser and then find out that I'm not representing him because ethically I'm not permitted to speak with him or her without their counsel present. So an important assessment to have initially as you enter into that meeting.
I completely agree. You want to have that done early. The other thing I always look for right off the bat is, does the charge appear to be timely? Because we've all gotten charges that are based on things that were 3 years before. And you say, well, it's obviously not timely. And that is something you can normally tell just in the initial read of the complaint. So I always tell people, look at that right away.
And it can become complicated because of an alleged continuing violation. It's important to separate out whether these were distinct employment decisions versus an ongoing process, because that also may effectuate whether or not only the charge, but the individual claims may be timely. One other point that I also wanted to point out at this early stage is considering what is the status of the charging party. That is, the person who filed the charge. Are they a past employee or are they currently employed? Because if they are currently employed and have filed a claim of discrimination, then we have to be very, very careful about our course of conduct moving forward because of a potential retaliation claim. We have to be so careful that we may not even want to disclose the charge to the employee's supervisor, because it's far better for that supervisor to be able to take the stand and say, I had no idea this charge was filed, versus, yes, I knew this charge was filed, and 2 weeks later, I'm terminating the employee. So very important to know the status of the charging party.
That is an excellent point. So at this point, I'd like to move a little beyond the charge itself. I know after I get the charge itself and I've done kind of an initial assessment, the first thing that I will ask the employer for is a copy of their current employee handbook. Because if there is a policy that this person was disciplined under or terminated under or something to that effect, I want to make sure that I have the actual policy right off the bat. What kind of things do you ask for right off the bat, Nancy?
In addition to the handbook, which is an important starting point to know what policies are at issue, I want to know if those policies have been followed with this particular employee, the charging party, and have they been followed in similar circumstances. I also want a copy of the personnel records along with medical records and the most important, supervisor files. Typically, the supervisor keeps some sort of records, whether it's a hard copy file of notes, whether it's an electronic file of emails as well as memos, whether it's something as simple as notes that the supervisor keeps in a notebook that the supervisor takes to every meeting. I want that critical information, including, of course, email communications, text messages, and whatever other means of communicating with the employee was utilized. That means, in addition to obtaining this information, I want to be very certain that the information is being preserved. And that takes us to the preservation notice, also known as a litigation hold, that must be issued within the company to each and every employee that may possess, either hard copy or electronically, information that is relevant to the claims or the defenses, a notice that it must be preserved and not subject to an automatic deletion or cleanout policy.
And I concur with every one of the things you listed there. And the reason is because when I have all of those things, the personnel file, any disciplinary records, emails, etc., is that I can create, and I know you like to create, a timeline of events, because there is nothing that helps an attorney more when crafting their case than to know specifically what happened in what order. And a timeline is how I do that.
I think we all, most of us at least, live by that timeline. And for me, the timeline is three-part. It not only has the date and a description of the key event or letter or communication. We also immediately create an internal Bates numbering system of all documents that are received from our client. And then we break it down by custodian. Is this the HR file, the supervisor file? And every single document has a number assigned to it. And that number then forms the last column on the timeline. Because ultimately, we're going to be in a position where we have to produce these documents, whether it be at the agency level or in court. And the sooner they are organized, and like you, I like them organized in chronological order, the better.
Absolutely. Now, the other thing that I like to do, it really gets away from the charge itself, but I think it's critical to understand the culture of the company. In other words, is this a company where one person is making all the decisions? It's their way or the highway. Or is this a company where they have, for example, I have a client that has a termination review committee. So before anyone can be terminated, a group of 8 people have to get on a phone or Zoom call and discuss whether or not what this person has done warrants termination, because they want to have not one person, but they want a whole group of people to agree, yes, this is enough, because they want to be extra careful. And I think understanding the culture of the company and the decision-making process is incredibly important when we are defending a client.
I agree. And as you know, in addition to representing businesses and companies, I also do a lot of work in representing colleges and universities. And in that environment, there are many layers to the decision-making process. If we're talking about a college professor, there are steps within that process in terms of promotion and tenure. If we're talking about a student, little bit off track from employment, but many students are involved in programs or internships. There too, there are many layers in that decision-making process, so that it's important to understand that different supervisors have different views. And while in a perfect world, and we all look for that perfect world, but it rarely exists, everyone is unanimous in the decision-making process. But oftentimes that's not the case. And it's important to know and understand what those different views are at this stage, so that we are able to develop a collective defense that is agreed upon and that addresses any of those differences.
Absolutely. And the other thing I like to do is I want to know if there have been charges like whatever the charge is in front of me before. And whether that be from the company or with regard to a particular supervisor so that we can kind of get an idea, was this an isolated incident or is this part of a more systemic problem? And I imagine, Nancy, you do a similar analysis when you're looking at a charge.
We do. And while we don't necessarily freely turn over all of that information when it's asked for by the investigator, we need to know and understand those prior charges and the outcomes as we develop and prepare the case. Consistency is so important in terms of process, in terms of criteria for decision making, but that doesn't mean that every decision, every time, is going to be exactly the same. But we need to understand, be prepared to explain it, and be prepared to distinguish it in the event it took a different path.
Absolutely. Now, the other thing I do early on when I have received a new EEOC charge, I always reach out to the assigned investigator. Generally, I like to do it by phone. Sometimes you don't have a phone number and you're just doing it by email. But I always like to reach out, number one, to introduce myself. But number two, the EEOC is always willing to give, I won't say always, used to always be willing, now most of the time is willing to give a 30-day extension to respond if you ask for it. And I generally try to ask for it on the front end and say, look, I just got involved and I would like the 30-day extension, because sometimes I'm not getting involved until 15 days have already passed from the time the charge has been issued. And I find that simply by reaching out, saying hello, and asking for a brief extension, most investigators are happy to see that there's an attorney involved and that they're willing to work with them. Is that your experience as well?
For the most part. Admittedly, I have an approach avoidance position with investigators, not so much at the EEOC, but I find the investigators at the PHRC a bit more challenging to deal with. But I agree with you, to the extent we can develop a good working relationship early on. And that doesn't mean that we're not going to have disagreements, have disputes about what information has to be turned over, about access to our employees. Nonetheless, if we develop a good, solid, respectful working relationship, there is a much greater opportunity to work through the disagreements and disputes and to resolve them in a manner that is not only in the best interest of litigating or defending the case, but is in the best interest of our clients.
Absolutely. And I find that most investigators, when they issue the charge, will also issue a boilerplate and very expansive request for documents. Now, asking for an employee handbook, okay, fine. I don't really have an issue with that. But a lot of times they're asking for employment records of people other than the complainant. And that's an issue where I do have quite a problem with that. And I have objected to many investigators. But I have actually found there have been times when I have called up the investigator and I've asked, what is it specifically you're looking for? Because there's no way I'm giving you the entire personnel file of this comparator employee or alleged comparator. But maybe you're looking for, a discipline record for this person. Maybe we can talk about something that's very limited, but there's no way I want to give you everything that you have asked for. And I find that there's a decent amount of success just in having that conversation, and that the investigator will limit what they're asking for quite a bit.
Agreed. And that again gets back to that good working relationship that you establish early on. We have, and I often use the term we, because when I'm working on a case like this, it is not, I don't consider myself to be the only one who is directing the case. First and foremost, it's the client's case. So the client is an important member of the team. Our paralegal, our associate attorneys are also involved, making this an efficient way to provide best of service to our clients. So when I'm speaking to the investigator, I will talk about the client's interest in protecting the privacy and confidentiality of its employees. We will go so far as, if we are required, and sometimes a subpoena will be issued out of the EEOC to produce employment records of other employees, we will obtain an agreement that instead of naming or producing documents with the name of the employee, they will get identified as employee A, employee B, employee C. And then we will redact, that is, blacken out any identifying information. And then we take a third step and put a confidential watermark across files of non-parties in action. And the investigators will accept that format because they're not necessarily interested in the name of the employee. They're trying to determine whether this employee is similarly situated to the charging party, and if so, whether they were treated in the same manner. So we are a big believer in protecting confidential employee information and taking whatever steps we can to not produce that information because, and it's important for our listeners to understand, once that information is produced, it may sit on the EEOC portal. And if the EEOC then receives a Freedom of Information Act request to produce all documents relative to company XYZ, that information may be turned over and may be used then in another claim against the company. So protecting that information is critical.
I couldn't agree more. So I always like to give our listeners 2 or 3 takeaways from our discussion. And I guess I'll start. And I think the first takeaway is that an EEOC charge response requires an understanding not just of what happened, but of the company as a whole and what the employee's specific job was. And the more you can understand the company and the job, the better response you will be able to give. Do you have a takeaway, Nancy?
A key takeaway for me is that the EEOC charge is the first step in the litigation process. It is not just a piece of paper that an employer receives and can be disregarded. It is an action item that needs attention, that needs serious consideration and response. And while many EEOC charges are resolved while at the agency level, the next step is that this claim may be filed in a court action. And at that point, whatever information you have submitted at the agency level follows with you and becomes part of the court action and becomes a much higher level type of litigation and response as well as risk. So take those charges seriously and respond appropriately.
Absolutely. And I guess the final one takeaway I'll give is that reaching out to the investigator early on in the process allows you the opportunity to shape their investigation before it really begins. And in many instances, narrow the scope, which is best for the company, who is, of course, our client. So with that, I want to thank you for joining us here on the Employment Law Counselor podcast, where we try to make sense of the world of labor and employment law. On behalf of myself and Nancy Conrad, we thank you for listening. If you enjoyed this episode, please leave us a 5-star review, tell your friends, and subscribe to the podcast. For more information on this and many other topics, please visit our blog at www.theemploymentcounselor.com. Until next time, stay safe and stay compliant.